versus whether Mr. McNabb's intervening action caused the death of the child and whether she could foresee it. So they're intertwined, in my opinion, on this. Essentially, in this case, the facts showing in the light most favorable to the state and the jury's verdict was that they lived in a mobile home in Newton County. It was Mr. McNabb, who was the child's father, Ms. Bell, who was the child's mother. The kids came back on October the 6th from spending the night with Ms. Bell's father. Ms. Bell's cousin came over. They used meth with Mr. McNabb. But the evidence also showed that Ms. Bell was up most of the nights that night caring for Kalia. Last saw her at about 5 a.m. When she checked on her. And while Bell was asleep, and newborn parents or parents of newborns have to sleep at some point, they can't watch them 24/7, he got up, crushed the infant's skull, and buried her in the woods, came back. And she was not aware of it until the baby sister, the older sister, comes in and says, "Sissy's gone, Sissy's gone." And they go and find that, that Kalia is missing. The evidence showed that Ms. Bell used drugs. She used methamphetamine, she used marijuana.
If you exclude the use of marijuana, the fact that she may have been a victim of domestic violence, tell us how the state could get to the point that she could be aware that he would possibly do what he did.
Right, well, and that's the issue, because there was never anything before this. Yes, there were acts of violence. There were acts of violence against her by him. I believe she was aware of some acts of violence against third parties by him, but these were all essentially petty offenses. They weren't anything serious. He had never hurt the other child. I'm certainly aware that he was not in that child's life for part of it, but when they moved in together, there was no evidence that he actually hurt the other child. So whether she could foresee that he would just snap and do this brutal crime, it's something that's so out of the ordinary course of events, that while it certainly could happen, it's not predictable that it would happen or it should happen. And so
where's the line when we talk about foreseeability in a world where something could happen but not necessarily would happen?
Yes, Justice Bethel. Well, with that, most of the cases on the foreseeability appear in the civil context. I cited several of them in my brief. The Enterprise Rent-A-Car was one that I think is kind of close to this, where basically a lady rented a car from Enterprise. It broke down because they had apparently negligently maintained it, and a Good Samaritan stops to assist her on the road, ends up attacking her and trying to sexually assault her. And the court said that natural consequences do not necessarily include all, as upon a calculation of chances which would be found possible of occurrence, such as extreme prudence might anticipate. So Ms. Bell certainly could have, if she was looking at every potential possibility could happen, could see this, but this isn't a reasonable possibility that this would happen.
So if I'll leave my infant child with a babysitter that I know to be an active user of a drug whose documented side effects are aggression, paranoia, hallucination, rapid mood swings. When I leave the child in that person's care, is it foreseeable, and I also know the person has a history of violence, not towards the baby, but in general, is it foreseeable that that person will cause an injury to the child?
I think that would be potentially foreseeable. However, here she did not leave the child with him. She merely tried to get some sleep while the child was sleeping, as parents of newborns do. So he was in the house. I don't think she had any authority to kick him out of the house or remove him from the house. And quite frankly, he'd been violent to her in the past, so potentially if she tried to remove him from the house, there could be violence as a result of that. She had also left the child with her father, as well as her sister during some of the days of its life. And I guess potentially she could have left and gotten away from that situation, but it's such a brutal and unexpected act that, I hate to say it, but people use methamphetamine all the time in the country, but you don't see brutal crimes like this every day. So it's...
Do you see them enough to worry about it? I mean, is that the standard that does it have to happen all the time for me to then believe it's foreseeable?
No, it doesn't have to happen all the time, but what it says in the Morris v. Baxter case is that they happen so frequently that they may be expected to happen again. So I don't think that this is a type of outcome.
So does it have to happen so frequently with this particular individual? Or does it just have to happen, if meth is the thing that we think caused this, do we have to have examples from this particular person? Or is it enough that we can look out into society and see that other people have done this? I mean, it seems to me this would be a very different case if the only drug involved was marijuana, right?
I agree.
Meth and marijuana are very different and generally cause people who are consuming them to do different types of things.
They do. But I think you would look at it both as society as a whole, but here, where there was evidence that they had used methamphetamine before multiple times and nothing like this had happened. So while it could happen, and it did happen in this particular case, it's not a frequent occurrence or something that is would be expected to happen regularly.
Well, nothing like this had happened, but this is a newborn child. How frequently had they cohabitated with an infant in those previous times when they used methamphetamine, some of which included domestic violence with respect to whoever was in the home, right? It happened to be an adult, but I mean, the fact that it never happened before, with respect to this child, obviates the fact that this was a newborn child.
Right, but there was still an infant, or I guess a toddler at that point in the household for about 6 months. I believe that he was absent for about the first 18 months of the child's life, but they were together for about 6 months before this happened, and living in the same household with that infant or toddler, and no incidents of violence had ever happened with that child. So I understand that there's a difference of, laying there and being completely helpless versus walking around getting into everything they can touch. But I certainly think that helps our argument, the fact that he had lived with a young child, but there was no evidence presented that he had ever been violent towards that child.
So setting aside for a second the fact that this particular charge was framed in terms of felony because it contributed to the death of the child.
Yes.
Would you agree that this would clearly satisfy sort of the lower standard of neglect?
Yes.
Okay. And
yes.
So the only piece that you're disagreeing about is the foreseeability and the proximate cause about causing the death.
Correct. Whether those actions directly led to the death of the child. And I think it's important, one of the few criminal cases I came across that deals with this was the Skaggs case, which dealt with an incident, I believe it was outside of a bar, where there was Mr. Skaggs karate kicked the victim in the chin. It was basically hard enough to lift him up off the ground, where he fell back, hit his head, and he died a few days later from brain swelling. And the court said that, yes, that's a foreseeable consequence, that if you kick somebody in the chin hard enough to lift them off the ground, they could hit their head and they could die from it. And so there's not an issue there with that.
Can I come back to the meth issue?
Sure.
The Court of Appeals in footnote 8 noted that there was no evidence submitted, or at least expert testimony, regarding the effects of meth. To what extent was there non-expert evidence in the record of the effects of meth? And if there wasn't, to what extent could the jury sort of rely on just their ordinary knowledge as people who actually live in this community?
Sure. Well, I would concede that the effects of methamphetamine have been well publicized in society.
Is that something that the jurors could sort of rationally, is that knowledge that jurors could rationally rely on in drawing reasonable inferences?
Absolutely. They're allowed to bring their experiences, their knowledge with them. That's part of what makes the system good, is that they have those experiences they bring with them and know that. So,
I mean, if a juror listens to the evidence that's presented and they say, you know, I have a cousin who took meth and he was crazy and he was punching walls and going nuts, I mean, that would arguably then cut against what you're saying, because that means the juror would be informing the view of foreseeability.
Maybe a competent lawyer would have, during voir dire, excluded that juror for cause, but.
hopefully. But,
I mean, and that cuts both ways, right? I mean, you could also have someone who had a different experience altogether, but if there is no evidence presented otherwise, that does leave that in the realm of the jury, right?
it does, but they did not, the evidence that they presented basically showed that within the confines of this relationship and this household, the methamphetamine use had not resulted in any violence toward a kid, and I don't believe that the previous hitting of her was ever tied to drug use one way or the other.
So is the fact that meth had not yet had that effect in this particular household, so far as the evidence shows, does that preclude jurors from drawing inferences about what they know meth use often causes in other people?
I think part of the issue here is that because they were not instructed on, they were not given jury instruction on proximate cause at all, I'm not sure that they were given the knowledge of the law to be able to draw that inference from that.
Do you have a jury instruction claim preserved?
I do not.
Okay.
And the last case that I want to touch on very briefly that I think is deals with the issue that the court seems to be most interested in, which was whether she was required to be able to predict his behavior or see that this was foreseeable. And that is the Gafford v. Duncan case, where a company loaned their employee a truck for work purposes and for work purposes only. He decided to take upon himself to use the truck to ram his, I believe his wife or ex-wife's car with that truck multiple times. And of course, this is in the context of a civil suit, so they sue the company for loaning the employee the truck. And the court held that one is not ordinarily charged with the duty of anticipating acts mala per se. And there's no, I don't think there's any dispute that what McNabb did in this case was an act mala per se. I mean, it's just horrific. It was not something that you see very frequently at this case was an act mala per se. I mean, it's just horrific. It was not something that you see very frequently at all, quite frankly.
Mr. McGinley?